from forward.
Thank you very much, CA Pushpendra Dikshit sir, for your nice words and introduction. I'm really grateful to CA Praveen Jain sir, who is contributing in a great way with the help and support on the platform of the GIPA, ADRP, APAR, PJ group of companies. I think he is contributing in a very great way for the cause of the society, for the cause of the accountancy profession, legal profession. And we are having the very prominent panelist. We are having Dr. S.K. Gupta ji, who is very prominent personality. He is the Chief Operating Officer, ICMI International ADR Chamber. And then, of course, we are having very prominent resource persons. We are having Dr. J.P. Singh sir, who is very senior advocate and mediator and trainer. And we are having solvency professional Sanjeev Ahuja sir, who is mediator and trainer and president of Missing Bridge. And of course, we are having Dr. Tripti Rathi ji, who is the assistant professor, Symbiosis Law School, Pune.
Symbiosis Law School, Pune wali, Tripti Rai.
Yeah.
Tripti Rathi.
Yes. And we are having very prominent organization other than C. Praveen Jain sir, who is of course insolvency professional registered valuer and a mediator also, and founder chairman of PJ group of companies and MSKM insolvency director, and advocate Piyush Jain ji, who is the director GIPA and corporate lawyer APAR legal, and of course Pushpendra Dikshit ji, who has authored the newest technology, is economy taxation, and of course my brother C. Vishal Singh ji, who is the member executive committee GIPA. And friends, let me tell you the way GIPA Professional Association is contributing for the cause of the profession, for the cause of the society, and in turn for the cause of the nation, something really great. And of course, Association of Dispute Resolution Practitioners is also the part of this VCM today. And as far as this role of mediation is concerned in global digital economy, I think everybody will appreciate. We are the senior professionals that in normal course, in routine course, if one do approach to the court of law for the commercial disputes, I think it would be very difficult to come out of the resolution, come out of the solution in the time-bound manner. So I think mediation is one way in of the alternate dispute resolution through which a great service can be done for the trade and industry by the competent mediators, by the competent professionals. And in India now we are having the best of the mediators. Of course, if we do talk of the mediators of late, India has come into mainstream, but now our professionals are contributing in a very good way, and they are contributing in other parts of the world also. And when we do talk of the mediation, that may be between the companies of the other of the foreign origin who are working in India, and for them in normal course to go to the court of law and to fight any case into the court of law may be very difficult. But as far as the mediation is concerned, internationally it is having the same language, same methodology, and for professionals also it is a very lucrative, very remunerative assignment. So it is a win-win situation. It is a very cost-effective way of the dispute resolution in a time-bound manner. The dispute, commercial dispute, can be resolved between two parties, between two industrialists, between two businessmen, and in the same, on the other hand, the professionals who are acting as a mediator they are also getting are compensated in a great way. So I think how the advocates, how the chartered accountants can really come forward and can try to have the expertise in this very important area of alternate dispute resolution. I think it would be very good for the legal profession, and it would be really very good for the trained industry also. And if the mediation will be in the mainstream in India, then the foreign investment will be attracted in a better manner in our country. So we will be helping out to reach India to third place. At present, we are the fifth largest economy of the world. If we are going to be on the third largest economy of the world, I think this methodology of the alternate dispute resolution through mediation will play a very important role. And when we are supposed to go to the position of the developed country by 2047, which is the target of the Prime Minister Modi, I think it would be playing a great role as far as the alternate dispute resolution and mediation is concerned, because unless and until the foreign direct investment is attracted to in India, it would be very difficult to reach out to that question. And when we are in the bigger economies, if we are having the maximum GDP growth, I think one of the most important reason is this, that now the foreign direct investment is coming in a great way, and we have to keep that pace going on. And the role of the legal professionals with the help of the mediation is very important to attract the foreign direct investment, and ease of doing business will be there through that. I compliment, I will not be taking your further time, as we are very eager to hear our learned resource person, learned guest speakers. I once again compliment the team GIPA, Praveen Jain ji, Pushpendra Dikshit ji, and all our honorable members of the GIPA. And I once again welcome our honorable resource persons, who are very prominent resource persons, who are going to guide us on this very important topic of the mediation. Thank you very much.
Thank you very much, Dr. CA, Dr. Anuj Goyal sir. Your word of wisdom are really worth appreciating, and you rightly clarified the role of alternate dispute resolution in today's time. And just to add a small bit of what you have just mentioned, is that in the realm of digital economy, where we are living in a borderless times, and we are interacting with the global economy in seamless manner. So digital economy is also going to play a immense role in the whole stream of alternate dispute resolution and the activity of mediation, where a lot of professionals can make a career out of it, and they can really collaborate globally. In with the help of technology, they don't need to travel all along. They can really make use of the technology, and they can really collaborate, and they can really add value to the profession, and obviously to their own professional well-being. That's really rightly said. Uh, Now I would introduce Dr. S.K. Gupta sir also, who is quite a luminary. He is having lots of education and lots of experience and etc. So I just with I have picked up the small summary of his career for the benefit of all the participants. Dr. S.K. Gupta is a postgraduate in commerce, a gold medalist, FCS, FCMA, PhD, corporate governance, with over 42 years of corporate experience in leadership positions with various public and private sector organizations in the domain of finance, costing, internal audit, sustainability, integrated reporting, company secretarial functions, and so on. Currently, Dr. Gupta is a managing director of registered valuer organization of Institute of Cost Accountants of India. He is also a CEO of ICMAI Social Auditors Organization, Chief Operating Officer of ICMAI International ADR Chamber, Dr. Gupta has chaired and addressed a large number of national and international seminars, conferences. He's been a visiting faculty at various leading business schools for over 3 decades. He is a member of various industrial associations. Dr. Gupta is editor in chief for various professional journals. He also is a very prolific writer. He's written over 300 articles and research papers. He's a regular contributor for the various professional national and international journals. And he is currently guiding 5 PhD scholars. So we are quite privileged to have him on board. And he has also conducted management development programs, both open programs as well as in-house programs. So it's really an honor to have Dr. S.K. Gupta amidst us to guide us and give us some. He can throw some light on the concept of ADR and also guide us. Dr. Gupta, you are on mute, sir.
Yeah. Thank you so much. Good afternoon, everyone. And it is always a pleasure to be on the GIPA platform, which is always full of knowledge, full of new developments, shared platform. And it's a great platform that you have created for the benefit of the professional fraternity. And the topic of discussion today, the ADR and specifically the mediation, is, I think, very, very timely and contemporary topic to touch upon and deliberate in today's interaction that we are having amongst ourselves. The times are changing, and the times are changing very, very significantly and rapidly. And this has brought about different kinds of business transactions, relationships, business models. And on account of increased complexity and diversity of these transactions, relationships, and models, it is but natural that disputes in the corporate sector have also increased manifold. There are onerous contracts, there are various conditions, terms put in the contracts and agreements, which at times become difficult to be complied with, even genuinely, by the various parties, and that probably prompts the other party to go for some kind of a litigation. And that's where the whole process and the complex web of litigation starts, because of these complex web of relationships and transactions. In a country like India, where we have developed quite a bit, we are the 5th largest economy of the world. We are on the anvil of becoming 3rd largest economy of the world within the next few years. But at the same time, there are segments of the population which are yet marginalized and which are yet not included in the wholesome process of economic development of the country. But nonetheless, dispute is something which arises not on account of, may not be only on account of intentional provocation by one party, but it can also arise on account of some kind of misunderstanding, confusion between the understanding perceptions of the different parties and stakeholders. And even these marginalized people are facing various kinds of disputes in their lives. And then when they knock the doors of the court, the process is very, very lengthy. The process is very, very costly. And that's where the whole problem is. So we started looking at what is the way out. Number of disputes are rising. Number of legal cases are rising, both in the corporate sector as also in the lives of the ordinary citizens of the country. And the courts are plagued with large number of unattended cases because of various reasons. So we thought probably we can look at and promulgate alternate dispute resolution, look at some other ways of settling out disputes out of the court. We all understand that mature people, even in the court, what finally happens? You fight a court out for 3 years, 4 years, 5 years, 6 years. End of the day, it is some kind of a settlement. कहीं ना कहीं कुछ सेटलमेंट की बात होती है कि दोनों पार्टी कहीं बीच में आके सेटलमेंट करती है 6 साल 7 साल लड़ाई करने के बाद. So the point is, why not first give a try by way of out of court settlement? If that doesn't work out, you always have the option of going to the court and trying to file the suit and take a remedy under the court procedure, whatever is available. That's where the importance of mediation comes into picture. Mediation is not new to the Indian context. But I think the architecture, the structure, the mechanism of mediation proceedings is now made structured by the Mediation Act of 2023. It has now set clear standards. It has enhanced confidentiality. It has also provided certain kinds of incentives, clearly delineated what kind of disputes can be settled by way of mediation and what kind of disputes cannot be settled by way of mediation. And it has also ensured enforceability. Of course, we don't really have the MCI in operation as of now, the Mediation Council of India, but nonetheless, I'm sure once the government has gone ahead with the promulgation of the Act, that's just a matter of time that we have in India a structured process and architecture of mediation being carried out. For all of us professionals, mediation is going to be the next generation of practice. We may be involved in very many different professions already as a chartered accountant, cost accountant, company secretary, insolvency professional, valuation professional. Similarly, you can add another feather or another dimension to your practice in the form of mediation. Mediation, as Anuj Goel sir mentioned, has a huge role to play in bringing foreign direct investment into the country, as well as, I may also add, is going to be a huge facilitator for creating more ease of doing business within the country. People who want to invest in the country, they look for, you never know when there might be some kind of a tangle with the other party, when there could be some dispute. What is the way out? How long will it take me to get out of that contract, get out of that scenario in case something of that sort happens? And IBC has been a game changer in that respect. And similarly, mediation also can become a very, very important device, very, very important architecture for settling disputes between the parties in a faster manner. Of course, the current Mediation Act is, as of now, providing for voluntary mediation. It's not been made mandatory. Some people are saying it will not have much of teeth. People still have, option. They would like to go for mediation. They may not like to go for mediation. But I think what the government has thought of is they would first like to give it a try. And when the results are available on the horizon, more and more people will optionally, voluntarily get into the mediation mode. And that's the ultimate objective of promulgating this particular act, creating a new architecture of alternate dispute resolution. So by encouraging parties to voluntarily come onto the table, explore avenues for resolution, mediation aims to not only ease the burden of courts, but also emerge as a global alternate dispute resolution mechanism, pattern, and architecture, which is really going to make the whole process of legal litigation much simpler, much more encouraging, and it will incentivize people who actually follow the out-of-court process in a much broader way. So that's my take for the time being. I'll stop here. Thank you so much for inviting.
Thank you, Dr. S.K. Gupta. I think you have very well elaborated the concept and the obviously underlying potential that people want to do business. And now we are living in a digital economy where we are interacting across border in a seamless manner. And of course, they would like to close the disputes. And what could be better than ADR or mediation? These are the alternate dispute mechanisms. A lot of potentials retired judiciary members, they can really play a key active role in bringing down the burden of litigation substantially, because apex court has been indicating that we should explore all possible alternatives to bring down the litigation, which is big time. Which is big time. And I was just thinking aloud that while we are talking about digital economy, I think ADR or mediation is going to help us maybe when we are going to think globally. Then I'm sure mediation will be one of the key aspects that will be picked up to settle even tax related disputes or non-tax related disputes or any other disputes across border. And there will be some agencies, there will be some arrangement, there will be some central agency. So a lot of potential, I think. Thank you very much, Dr. S.K. Gupta sir, for really giving your insights. We really appreciate. Now next, our esteemed guest is Sanjeev Ahuja ji. Sanjeev Ahuja is a chartered accountant. He is an arbitrator, mediator, insolvency professional, and strategy advisor also. He is a lawyer, cost accountant, alumni of ISB, and he has done his graduation from SRCC, Delhi. Sanjeev Ahuja ji is a hardcore strategist at his heart, endorsed further by his exposure and experience spanning more than 30 years across industries, including consulting, infrastructure, FMCG, automobile, and textiles. As I mentioned, he is an expert in mediation, negotiation, and communication, insolvency resolution, advisory, transition, change management, and so on. Currently, he is a president at Missing Bridges Solutions and Resolution Forum. He is also founder director at Insolvency Clinic. We are really honored and pleased to invite you, sir. Kindly give us your thought about the concept and illuminate us. C.A. Sanjeev Ahuja ji. Sir, you are on mute, I guess. You'll have to unmute. Yeah. Sir, you are not audible. Ahuja, sir, you are not audible.
Are you able to hear me now?
Yes, yes, sir. Very much, very much.
Okay. So that means apparently technology is again playing different. Let me remove the headphones in that case. So that's clear now, right?
Yes, it's loud and clear.
Thank you, Mr. Dikshit, for the introduction. And good afternoon, friends. Good afternoon, organizers, especially Mr. Jain. I see Mr. Singh there. Namaskar, sir. Then we have Dr. Gupta and of course Anuji. So nice. Before I start, Mr. Dikshit, आपने बताया कि tax के बारे में भी probably we'll have mediation going forward. Answer is yes. Couple of years back when we had Chief Justice Bogde, right around that time, they made a statement along with the finance minister saying that we should actually look at all kind of commercial disputes, including taxes as well. And in other jurisdictions, there is definitely a provision. There is a discussion already happening. The challenge is that, once we work in a system, there is a requirement of a lot of enablers, provisions and rules, because a person who works in a system, he's bound by the processes and the rules and the procedures. So I think somewhere we need to handhold and really be very open on the mindset. But as I move forward on some discussion points, we'll try and cover as to what ails the PSUs or the government machinery, in spite of wanting to adopt this mechanism or non-adversarial, where they get stuck. So we'll touch on that. So right. So this is surely a topic close to my heart. So I mean, when Mr. Janet asked, though you can see me, I'm actually in informals. I'm on a small break vacation, but then this was too important topic to have missed this opportunity. And at any point in time when I get an option, I definitely want to share my thoughts. So I have been an IP for almost about 8 years, which is ever since we had the IBC notified in 2016. And I have used mediation and other non-adversarial tools and techniques, even while being an IP on the ground, as a resolution professional, as a liquidator, because to me, irrespective of the kind of dispute we are talking about, we are dealing with human beings in the first place. And there are people who always want a solution to their disputes and the problems. Then only we end up discussing with a company or a different legal entity. But at the back of every dispute, there is some human being, whether it's a promoter, MD, CEO, CFO, disputes in a particular way through adjudication, through intervention of a third party. But wherever there is a possibility for a dialogue, for a for a discussion, for a conversation, we have seen amazing results. So I think the conditioning of minds is something which has to be at the topmost priority. Where over the period, I think we've all got into a situation whereby we prefer a third party to take a call on our behalf and tell us who's right and what is right for us. On the contrary, like, we can always sit together, have a discussion with each other, look at a give and take, and really understand. So, assuming that we have the participants who are for sure insolvency professionals, some chartered accountants, and of course other professionals from legal field. So most of you, I'm sure, like you already have a fair of the concept called mediation, which is the most noble, I would say, non-adversarial tool of ADR. But it's important to also understand that in most part of the world, and India is no different. When we say ADR, we for a majority of people, I think 90% or even more, well, percentage might have come down slightly over the period, but still a huge majority of people, the moment you say ADR, they say we know what is arbitration. So for them, ADR and arbitration are almost synonyms to a very large portion of stakeholders across the spectrum. Now, why is this the case? Right? One can go into a debate. As Arbitration Act has been there for a while now, 1940, and then eventually, we had changes, and then 1993, 96, some changes in 2015, 2018, 19. So there's a lot of action in arbitration and conciliation space, and I think that is where people were aware of this act, and they found arbitration as an alternative dispute resolution mechanism. But ever since, I guess, August 2019, when we had the Singapore Convention, which is at par with the New York Convention of 1954 for arbitration, there's a lot of talk on mediation. And then, of course, I think in between COVID happened. Otherwise, India had been a signatory to the convention. But post the convention, we now have our Mediation Act. In fact, I think day before we have the rules which have come out. For the mediation. So I think there is a lot of action, noise, and voice now around in this space. So it's very important for all of us to contribute to make sure that mediation actually comes into mainstream and becomes the port of first call. Dr. Gupta did mention about the mandatory and the voluntary part. I remember when the committee was asking, was seeking some suggestions. I mean, we were very hopeful that probably they should make it mandatory. Though there is a slight confusion as to when we say mandatory and somebody comes back and say, by the very premise, by the very fact of mediation as a definition, as a concept, it has to be voluntary. Totally with you. But the discussion, what we are saying, and when we say mandatory, we are very mindful of the fact what we expect to be mandatory. Mandatory is just a mandated attempt to try and seek in it a particular settlement, right? Very much on the lines of the Commercial Courts Act 2015, Section 12A makes it mandatory. Before you file a suit, you need to try a pre-litigation mediation. Of course, there's a proviso, and we all end up taking the benefit of the proviso because we need a urgent interim relief and all that. So it probably kind of, gets diluted. The whole idea was to bring the horse to the well. If horse, in spite of that, refuses to drink, so be it. But does the horse know that there's a well? Only from that context, we thought if it could be made mandatory for an attempt to be made by everyone in all the disputes. I mean, currently the first schedule is pretty long, frankly, for our comfort. First schedule actually says the exceptions, where all the Mediation Act won't apply. Now that's too lengthy. Give me an option. We would have wanted it to be as little, as sketchy as possible. Probably, criminal, clear cases of fraud, but most of the rest of the exceptions should have been attempted because mediation is like a homeopathic medicine. We are not having any side effects. Only thing if something happens is going to be good. So maybe there was a lot of sense in making it mandatory. In fact, the first draft of the mediation bill with that time, it did say it's mandatory, and over the period, I'm sure, like, the forces apparently had a play, and government also wanted to probably, take a cautious call not to get into, a kind of a confusion. So for now, it continues to be voluntary. Now, let's understand mediation a bit differently. Mediation is, it's a settlement through a certain process. A negotiation is also a settlement, but a negotiation is normally between the two parties. The moment you think the parties are, because of ABC reason, the egos, the emotions, whatever be the reason, just in case they are not able to talk to each other, that is where a recommendation is made for a mediation, which by the process, by the very definition, means a third party, which is the neutral, whom we call a mediator, is supposed to be sitting in between the two parties who are in dispute. The whole idea is that this person is expected to drive a process. Of course, again, there's a debate on whether he should be a subject matter expert or a process expert. We leave the debate for some other day. If you ask my broader view, I would any day want the mediator to be an expert on the process. The parties, in any case, know much better than us. What do they need? Why do they need? And how much they are willing to give and take. So from that perspective, I guess the process has to be driven nicely. And the very fact that there's a third party requirement who steps in and who drives the process brings, or rather reduces, the gap of distrust of the issues of the dispute, the conflicts between the parties, and empower the parties so that they, on their own, they can discover an amicable solution. On their own, if they were to do it, then of course it's nothing but a negotiation. And hence, mediation is also called a assisted negotiation. So if you were to see a top-down or if I were to say, let's understand that wherever possible, to the extent possible, apply the principles of mediation. That is where the chances of success are going to be much higher. So what is the essence of the concept? What are the highlighting features? It's a solution-oriented approach. We all look at solution. I mean, I'll come back to this particular point, because how many of you are looking at, I mean, once you have a dispute, are you looking at a justice or a solution? Would justice always lead to a solution, or a solution is something which the parties really expect for each other to try and resolve the dispute? Now, so similarly, the other highlighting feature can be flexibility, thinking out of the box, looking at preserving the relationships, a peep into the future, a win-win situation, and party autonomy. What has over the period got added is the voluntary part of it, the confidentiality part of it, the cost part of it, or the timelines. All these features, to me, should be suiting the context. Because the very fact we said, it could have been made mandatory as an attempt, or it might not be as cheaper as one expects, because the mediator also is a professional. He's also going to spend time. He's a trained guy. He has to spend time, energy, drive the process, and actually help you get the certainty and the finality. Why he or she should be cheaper, we really don't know. In terms of timelines, I think it totally depends on the complexity or the multiplicity of the issues and the parties involved. Now, if it takes time, it takes time because to the extent we say voluntary, and if the parties are willing to continue having the trust in the mediator, and the time is likely taken beyond what we thought initially as it would be taken, then what is the problem? Because on its own, if the parties are still working out to discover an amicable solution, they are still out of the court, and that's probably the whole objective. So, I mean, we have to look at things in a much larger perspective, and that is where we should be able to apply mediation or the non-adversarial process either in bits or in as a whole. So similarly, the Act talks about 120 and 60 days. We as mediators, I'm sure, we clearly we have a view that yes, ideally it should be time bound, but what is the alternative? I mean, if you go to the court, is it time bound? The kind of uncertainty what plays out later, why don't we allow as much time as required and desired by the parties, and why we put a timeline? So these specific points with regards to the cost of the timeline, I think we need to be more flexible with regards to each of these points, and they should be suiting the context. Other point is mediation is good. It is good because of the inherent strength in the feature. It is not to be made good because something else is bad. Why should we say the courts today are under pressure with 51 million cases, and hence mediation is required? Mediation as a concept, if we really understand, then that's been there, and today it's being formalized. So it should be honored, should be used, we should embrace it for what it is. A hypothetical situation, tomorrow will lose its characteristic or the importance. Answer is no. So let's not put the cart before the horse. We should look at this dialogue, a conversation, maybe directly or through a third party called mediation, as the first port of call. If you are successful, great. Otherwise, nobody is giving guarantee, not even a judge for that matter. So we should again, be very open-minded when we're talking about this thing. And I was saying that, in a quick discussion, I would say when I compare it with arbitration, conditioning of minds is something which we spoke about. Then the codification of the law we spoke about. And today there is a code for a mediation law as well. So let us be very clear as mediators that we should not get strangulated in terms of the creativity or the flexibility or that accommodative nature, thinking out of the box, which is the key feature of the mediation as a process. Because again, we say, at the cost of repetition, I say, parties in dispute seek a solution. If it comes through justice, great. If it comes through an order or a judgment, it's great. But frankly, the priority is the solution. The very simple, most basic example we keep giving all the time is that simple orange story, where two children fight, and one of the parent comes, takes a knife, splits the orange into two, gives it to both of them. Both the children are unhappy. And then the other parent comes, seeks the reason for the dispute. One wants the flesh for a project in the school the next day. Other one is hungry. All he or she, the other parent, has to do is peel it off, give the peels to one and the flesh to another. Both of the children are happy. Now, that's as basic as possible to actually tell what miracle of mediation as a concept can actually do. Now, let me jump to something which is more objective and the topic of today. So when we are talking about the banking and the finance sector, which I was supposed to discuss with regards to mediation, now essentially what we are saying is, you speak about banking or finance sector, so you are talking about banks, you're talking about NBFCs, you're talking about probably money lenders, and then on one side, these are the institutions you're talking about. On the other side, what you're talking about is a commercial or a business dispute. So earlier, the notion was mediation as a concept was only primarily used for matrimonial disputes in a family. Things have changed much ever since across jurisdictions. When we interact with mediators in US, in Europe, in Singapore, I think commercial and business disputes are more and more being handled through mediation, and that's the best part. And the confidence is so much that they irrespective of the stakes involved, when the parties sit with an open mind, when they sit with a problem-solving approach or a solution-oriented approach, they have been able to figure out through a give and take, through understanding the other side's perspective, and actually agreeing to a settlement, which is somewhere halfway through. Now, I might say somewhere halfway through, but at the end, what suits the party to the numbers? What is acceptable to two people in a dispute, which can be anything, till the time it's legit, it's within the four corners of law, it's adhering the process, and both the parties are happy. They're doing it with voluntary mechanism, which means the chances of they going back on their words are much lesser. We have seen in arbitration, the moment an award is given, the party against whom the award is, by default, more likely than not will go under Section 34 to challenge the award, irrespective of how how much the options for challenging the awards have been reduced over the period, right? But at the end, the first attempt is to try and challenge the award. So essentially, we are saying the success ratio is even less than 50% when people are not even happy getting the award because they didn't get the award or the order or the judgment the way they wanted. It had to be limited to the prayers made. There has to be a limit of discretion by the judge. But in mediation, who's deciding? It's the party who are getting empowered and they are deciding on their own what do they want. And there would not be a successful mediation unless until both the parties, both the sides are agreeable to that. So see, if it's an amicable solution, the chances of going back on their own promises are very little. And hence the whole debate of enforcement, which had made a lot of people as a fence sitter till the time Mediation Act wasn't there. And today, of course, we say the settlement under mediation carries the force of a decree or a judgment. I mean, a lot of people have said that, what about the enforcement of a settlement? I mean, to us, either it's a failed mediation or a successful mediation. A successful mediation means you don't need enforcement. Parties on their own have decided, agreed to do something, and both of them have agreed, both the sides. So they'll be more than happy to take it forward and complete their promises. And if it fails, for reasons known, unknown, genuine or not genuine, I think let's not shy away in calling it's a failed mediation and be happy with it. Because again, the time spent, even as per law, would not affect your limitation period. That is one. But in any case, I think, as I said earlier, it should be only taken as a homeopathic medicine. If at all something accrues, it will be for your benefit. Otherwise, you have all your other alternatives, including the court, as very much as an option as it was in the beginning of the mediation. Now, linking mediation to IBC, as we quickly heard from Dr. Gupta also. So some real life examples I can quickly give you, because we've interacted with the banks, with the NBFCs, with HNIs, with the fixed deposit holders, and in IBC, even home buyers are called financial creditors. So they have not lent money, but because of ideally, one of the bigger case, JP, that was the best way to deal with home buyers. But the context is that everyone who's lent money, every lender, every financial creditor sees the relevance of mediation. The difference what we could take or call out over the period was somebody who works in a public sector or a government machinery has his hands tied up. It's not that they're averse to mediation. Versus a NBFC, a private bank, slightly more flexible, slightly more aggressive in terms of taking a call, or a HNI. These people have been really at the forefront in terms of trying to adopt mediation, engage people like us, and look at settlements so that they get the certainty, they get the finality. Because then they get to compare with what next. If it's not mediation, if it's not settlement, then what next can happen? The next is either you go for arbitration or you go to the court, and then it takes forever. And then, as I said, even an arbitral award is prone to challenges and all, and the court probably can take forever. So our experience with NBFCs, yes, they have been interacting with MSMEs and startups. There's a lot of lending on different accounts, the term loans and the short-term loans and the working capitals and all that. What we have been suggesting and what they have really appreciated is, let us get into a dialogue if there's a delay. Before it becomes the NPA or even after it becomes NPA, what are the other tools, methods, mechanism, options you have? Exactly has been the main reason why he's not been able to pay. And in most of the cases, the restructuring has happened after those dialogues, because they could see that there are genuine or there are such exigencies which were beyond control of the promoters, of the MSME or the startup. Reasons could have been, as varied as possible. Smaller disputes, larger disputes, and so much so that if I were, to the people who are aware of, IBC and how, this law has evolved, the jurisprudence, we have all seen Vidarbha judgment from Supreme Court. Right now, frankly, if you see, there is that element of trying to give some discretion to the bench so that they can check the reason for the default. And in spite of that, though, I mean, there was a kind of a backlash because the debt and the default finally had to be admitted in 14 days, which was not happening. But again, if you were to stretch it, the whole idea of giving an option to the corporate debtor in spite of a proven debt in default and giving a notice and hearing him as principle of natural justice, nothing but trying and understand what went wrong. And in few cases, we figured out that because of arbitration against the, with the government authorities, or for some genuine reason, if there's a huge amount which is getting paid and about in due, but in the interim, the financial creditor or any other person who's aggrieved, he or she brings the corporate debtor to CRP, is unfortunate. Now, that is where the debate continues, and NBFCs and HNIs and a lot of other money lenders, we have seen when we've got engaged or when we have tried to do some advocacy on the mediation, these people have really appreciated the fact. Now, I want to give you some real life examples. Won't take much time. I mean, 3 or 4 quick, references I'll give. So, in one of the cases which I handled as a resolution professional, we actually got bank guarantees worth 50 crores back from a state transport authority. Now, without going to NCLT for sure, I mean, these were early days. Now, in fact, at the drop of an hat, people want to, approach NCLT under Section 60, subsection 5, which, okay, half of it, I may not be able to comment, but for the rest half, my suggestion to my fellow colleagues, fellow professionals, at least in ITC space, please talk it out. Please try and understand. Please try and don a hat of a mediator. And I'm sure you'll figure out that there is something which can be done through a dialogue, through a conversation. Now, this may not be a true straight-jacketed mediation, which is where I wanted you to also understand the concept in parts and as a whole. Now, it's not that 2 parties come to you and you sit in between and you decide. The whole idea, what you need to pick up from mediation is flexibility, accommodation, have a dialogue, understand, empower the parties, see what can be done, give and take, again, what is legit. So all we had to do, I mean, in my case, in this particular reference which I'm making, I had to meet the MD, the CEO of the State Transport Authority. It was 1.5 hour wait for him, whose RP doesn't bother. So of course, with permission, we went, had to wait for long. After that, when me and the existing management team, when we met the MD, I think in all about 10 to 15 minutes, he broadly got just what exactly we're trying to explain, that the company is insolvent, is being treated for insolvency. It doesn't mean it's dead. It doesn't mean it's liquidated. It doesn't mean it'll be the end of the story. Give us time, but help us in transition. We are adhering to a process. This, that, all we got 15 minutes. Then I alone was called for next 2 hours. I had to explain him in detail what IB says, what is CRP, what we can actually extract from a well-run process. And believe me, sir, within, I think, 30 odd days, this gentleman writes us back and says, without invocation, we are giving you guarantees back, but help us move your contracts, unfinished contracts, to a different party. And of course, we had to agree with, with folded hands. And the COC was zapped as to how is that possible. So 50 crore guarantee without invocation during the CRP, coming back to us without intervention of NCLT, is one such example. We need to discuss, converse, communicate, have a dialogue, and things can be much better. Similarly, in one of the cases, after the DRI raid, there was a confiscation of some bullion and some other assets of a corporate debtor. When we were appointed, after about 4.5 years, ever since the confiscation happened, I mean, we had to reach the custom authorities. It took 4 months. Let me not say it was a very pleasant experience. 4 months of frustration, going back, coming, making them understand that this is what the law is and all. And again, to our pleasant surprise, these people gave us the goods which are confiscated back, rightly data, who and accordingly as a RP, we have the first right on that. We had to pay some duties to them to get them released. All whatever had to be done as per law was done. But without even filing an application to NCLT, this continues to be one such kind of a case precedence in IBC till today. So getting that stuff back, telling the COC, selling it through an auction process, running the entire CRP. Now these are real life examples what I'm giving you as having tried. Now have we been able to be successful all across? Answer is no, but it gives a lot of confidence that this is a possibility. Similarly, one of the discom companies, 5 years old recovery was made. Recovery may not be the right word, but when we checked our books and there was an amount due from them, all we did, we had to go there initially. In COVID, it was difficult, but post that, once we went, series of meetings, and those people agreed, they got the opinion, whatever needed to be done in terms of emails, putting the right citations on the ground, helping them whichever way, right, going up to the Director of Finance MD. And eventually they gave us the money which was due for last 5 years. So these are real life examples. All we wanted was, let's take the initiative. Let's not presume, because for us, it would have been very simple, file an application to NCLT. They'll send a notice. The other legal department will get into action, and probably we would have continued with the CRP for until now. We have seen such cases. I'm not saying there's no blame game here that the judges can't decide, the benches can't, or the stakeholders always want to have a shortcut. Answer is, in those 2, 3, 4, 5 minutes of time at a bench for the members is practically, don't be drawn ahead of like a negotiator or a mediator, and actually take that initiative. 50% percentage as the probability to succeed, I would say why not? And for the rest, you meetings in discussion with vendors to come rather continue company or a CD as a going concern. I think that whereas mediators, talk it out, have patience, right? Show empathy. The other person is also right. They're not getting the money which was due prior to CRP, and you are wanting a vendor to continue with the services without any payment during the CRP. How difficult it is. At times, how unreasonable for that matter. But again, through a dialogue, I think more often than not, we have been successful. So I'm almost touching my timeline for about 5 o'clock. Now, I think I've given quickly sum up what essentially I'm doing. We're wanting to embrace the concept, and we are wanting others to also. On one side is capacity building. On the other hand, we want the promoters, the companies, the borrowers, all the parties in dispute, irrespective, try it out. Trying is not costing you much. All you need is positive attitude, or open mindset, a solution-oriented approach, some patience, some flexibility. Is there a guarantee? I said no, of course. It's just an honest attempt. The bigger problem probably is broken into smaller, so that we are able to address a large part of that problem. And something what is left, you always have alternatives, right? So there's a bit of art and a bit of science. We are not saying a 40-hour training as you normally hear a mediator is expected to undergo. We're not saying that one can really change overnight and become an amazing mediator. A lot of it is art and a lot of it is science. But let me tell you, the artist has a bigger role than the scientist. You need to really work on the craft and the skill. And yes, through the trainings, we do discover the mediators, I would say. And so, yeah, it's a way of life and approach. And if we all believe in, I think 50% is a sure shot win, because it's going to show in your personality, in your work, in your culture. And I think that's the way forward. So that's from my side. I would have a hard stop, but more than happy to have 1 or 2 questions in case. Otherwise, I'm happy. Thank you. Yes, Mr. Dixit. Just in case of any question or something. Otherwise, I'm done. Thank you.
No, at least I am crystal clear. You have very well articulated the concept and the fact that it's an art. It's a blend of art and science, but more tilting towards art. And it's I think the way you elaborated, Sanjeev ji, it's no more I think what you call it, unbridged kind of thing. It's already you bridge the gap. You
Okay.
mentioned,
So it's no
yeah, it's not
more a
unbridging.
basic bridge.
Yeah, it's no longer missing bridge.
Right.
You got bridge the gap. And I thought it's really very intriguing in the sense that you draw a parallel with this what you homeopathy medicine or Ayurvedic medicine, which is always kind of economical in terms of the allopathic, and obviously it doesn't have any side effect, and it's more on the will or the willingness of the two parties who go ahead and try to find a solution instead of mediator is just gonna go facilitate the transaction. And obviously communication and the way you do it, it has a lot to say. I think very well articulated, sir. I am absolutely clear. I think any participant who has got any question, please raise your hands. You can ask one or two questions quickly if you have, else we can reach out to Sanjeev ji later and we can proceed.
Thank you, Sanjeev ji. Hello.
So, okay, with that, I think I give baton to CA Vishal ji. He will carry on the process, and he'll introduce another distinguished speaker.
So
Thank you
there
very
is a
much.
question in the chat box, sir.
Oh, is it? Just a
Yes, sir.
minute.
Thank you, sir.
Vishal ji, just give me a moment.
Okay,
There is a
sure.
question from Mr. Asit Mohapatra. Sir, is any training course required to become a mediator? Quickly, answer is yes. More you can hear from Sanjeev ji. Sanjeev ji, can you please?
Okay, so sir, yeah. Okay, so frankly,
Your voice is breaking, sir.
this TR concept which is worldwide. Now, there is a lot of debate on what the history is about 40R. More important is that, for those 5 days. Is it better now? Anyway, audible?
Now it's better. Kindly, sir, repeat once for the benefit of all. Sanjeev, sir? I thought there is some technical glitch on his
Let me
side.
write the answer then.
No, now you are audible, sir.
Okay, voice. Now, if I'm still.
So, okay, maybe, sir, you can just write it down and maybe we can, reach out to you later. In the interest of time, Vishalji, just carry on. Thank you. Thank you very much.
Thank you. First of all, I'd like to welcome JP Singh, sir. I'd like to introduce about JP Singh, sir, is a senior advocate and a pioneer in the mediation movement in India. He is appointed as a foreigner of organizing secretary of Delhi High Court Mediation and Counsel Center, and also known as Samadhan. He is presently the president of Madhyalaya International Council of Competition, and sir is appointed observer by MCPC Supreme Court of India for mediation, the trainer of Faridabad and Jharkhand. And I welcome, sir. Please give some insight about the mediation, and it is a great privilege to hear your experience and your long of experience. So we will be grateful for such lightful thoughts. So please share.
Thank you, Vishal. Thank you, GIPA. I had earlier an occasion to interact with GIPA when I did a 40-hour training for the chartered accountants for GIPA. I mean, just by the way, since that question, Sanjeev had that technical problem. See, the training, 40-hour training is merely a threshold training. ultimately, after doing the training, you have to undergo practical training along with the experienced mediator. And thereafter, we do advanced training in Delhi High Court. And after you've done your advanced training, that you independently start mediating. There is no standard. This 40-hour training is, as borrowed from America, because training, first of all, the mediation concept started in America in 1976. So that's where, and we started this movement in 2006. And as was said, I was the founder organizing secretary when Bar was up in arms, because Bar thought if all the matters get resolved, what will happen to the lawyers? But unfortunately, the statistics show that if 100 more years, no fresh filing is done in India, the litigation is not going away anywhere. So therefore, we need not worry about what will happen to the legal profession. Thank you, Dr. S.K. Gupta and Mr. Sanjeev Ahuja. You have set the ball rolling. Today, mediation is a buzzword. It existed in the Arbitration and Conciliation Act 1996. Section 30 says that the arbitrator can use mediation as one of the processes for purpose of resolving dispute. But it never really happened because we had no trained mediators in India. Now, Sanjeev ji correctly said that behind every commercial dispute or behind every organization, there are human beings. Human beings have conflicts. And basically, mediation is about two life skills. One of them being negotiation, the other being communication. Now, these are life skills which we need to deal with day in and day out of conflicts and disputes which arise in our daily lives. Now, let us go a little back as to what was the need for ADR. Suitability and effectiveness of litigation in dispute resolution has been subject of debate for decades, which called for alternative dispute resolution mechanisms. Though ADR methods evaluated and decided contentious issues, but they are not substitute for litigation. Courts deliver justice by making authoritative decisions. But due to non-binding nature of ADR, courts generally review the validity of ADR methods and outcomes. I would therefore refer to ADR as complementary dispute resolution rather than alternative dispute resolution. ADR has, however, resolved some of the weaknesses of litigation, which are high costs and long time of evaluation. However, final resort to litigation becomes necessary for enforcement of the decisions under ADR, especially when these decisions are challenged, like an arbitration. When an arbitration award comes, it is subject to challenge under Section 34 of the Arbitration and Conciliation Act, which again brings in the courts in the forefront. Because it's only once the 34 is finally disposed of that the award becomes executable. So therefore, we can't wish away litigation or court system. The underlying philosophy of mediation is that parties have bargaining power and that continuing relationship is essential even after the dispute has arisen. Mediation is driven by actions of good faith when parties are ready to discuss evaluation of disputes with openness and honesty. Mediator controls the process while the parties control the outcome. The mediator does not impose a decision on the parties. Mediation upholds confidentiality while exploring good faith and trust. The proceedings are confidential and without prejudice. And whatever transpires in these proceedings are not admissible in subsequent proceedings. Mediation actually affords parties an opportunity to generate creative options to solve their disputes in a manner that focuses on the future and not on the past. See, a petition, when it goes in court, it narrates what was the dispute, what are the actions which were taken, and why did the dispute arise. All this has happened in the past. And finally, a judgment comes, who's right, who's wrong. But when we look at mediation, we firmly believe that no disputes are resolved in the past. And therefore, we look at the future relationship of the parties. Agreements can be reached sooner and through a less costly process. Agreements are more easily implemented in comparison to verdicts by courts and third-party directed decisions like arbitration. As Sanjeev ji said, these are solutions of the parties themselves. So therefore, they honor it. Mediator is a facilitator who manages the dispute resolution process, remaining impartial and neutral. Now, there is, under the Arbitration and Conciliation Act, there is a concept of conciliation. Conciliator is appointed who discusses the disputes with the parties and then prepares a solution based on what the conciliator considers being a just compromise. See, because he is a domain expert. Sanjeev ji also talked about a person being a process, controller of the process and a person who has knowledge of the subject. So conciliator is generally a domain expert. Conciliator is, that sense, may be regarded as a designer of solution, unlike in mediation, where parties are guided to design their own solution. So a facilitator, mediator is merely a facilitator. Though conciliation and reconciliation have found mention in several statutes since the early 1950s, it was only when Section 89 of the Civil Procedure Code was amended and enforced in 2002 that we in India sat up and noticed mediation and conciliation as form of dispute resolution. Now we have the Mediation Act of 2023. Again, this was necessitated because we are signatory to the Singapore Convention and we needed a domestic law to ratify that convention. And that is the reason why now we have our own Mediation Act 2023, which emphasizes settlement of commercial disputes through mediation. Commercial disputes are defined under the Commercial Courts Act. It includes construction and infrastructure, contracts, including tenders. The definition is quite expansive and covers a whole gamut of what we call commercial disputes in common parlance. Now, it was sometime in 1970s, if I remember correctly, a Calcutta High Court judge in a judgment had written that construction contracts have disputes inbuilt in them. If these disputes are not nipped in the bud at the appropriate stage, they can have a cascading effect at the end of the project in terms of costs, delays, and relationship, which will affect the ongoing projects. Through mediation, you can look at deciding disputes which arise during the execution of the contract without hindering the progress in completion of the remaining work. The distinction between now mediation and conciliation has been done away with in the Mediation Act 2023. What mediation requires, however, is cooperation from all the parties involved in the dispute. Sanjeev ji talked about compulsory or mandatory mediation versus it was also taken up as voluntary mediation. See, mediation is about resolution of disputes by parties, but it's a forum for self-determination. Parties can be forced, to sit on the mediation table, but they can't be forced to settle. So what pre-mediation or a compulsory mandatory mediation does is it only brings the parties on the table. Thereafter, it is for the parties to resolve or not to resolve the dispute, depending on what kind of offers are put on the table. There has to be good faith and mutual commitment to find a solution and move on with the work. Let me tell you, several high-value commercial disputes to the tune of several 100 crores have been settled using the process of mediation and conciliation at a very nominal cost and during the span of just a few months. Let me just name those figures to you. In one of the cases where there was a public sector enterprise, the amount was 758 crores. In one of the conciliations where I was a party as a conciliation tribunal, the matter was 132 crores. And as I said, it was just about 4 months that the matter got resolved. So this is what we are looking at when we talk of mediation. In my opinion, the construction industry and the real estate sector will be greatly benefited by utilizing the services of a trained and qualified mediator in all such cases. An important step, however, which we need to keep in mind is drafting proper clauses relating to resolution of disputes in the contracts. There should be series of steps in the overall dispute resolution process, including mediation. The intention of such steps is to keep the parties outside the court or arbitration. Now, those steps can be project neutral. You can have an expert, a neutral expert who can evaluate when the dispute arises as to the consequences of how the dispute should be resolved. You can have a dispute resolution board. Some of the government bodies have that. Of course, mediation and conciliation are steps which can be, of course, resorted to. Inclusion of such steps is useful in disputes where the parties have a long-term relationship and want to continue with the same, especially when you're looking at construction contracts, and because that's what we are now talking about. Construction sector, real estate disputes. The contract spans over a period of time. And therefore, when there is a long-term dispute or relationship which the parties enjoy, and they want to continue with the same, these steps become very, very necessary. Instead of embarking on a confrontational path, such a step provides cooling off period to the parties to assess reason and evaluate their options before starting arbitration or litigation, which is likely to escalate the dispute. These are cost-efficient ways of managing dispute. It acts as a filter. Some disputes get resolved quickly, and only part will go for arbitration or litigation. Let me give you another example of, one of the matters under Section 12A. Now, Section 12A of the Commercial Courts Act, for the first time when it was amended, brought in the concept of pre-mandatory mediation. It saved a limitation, the time that you spend there, and the conciliated settlement under 12A has the force of a decree. Therefore, you don't have to go back to the court, ultimately, for purpose of enforcement. Now, this is a matter where parties agreed on almost all the monetary considerations, but they got stuck on the interpretation of a clause in the contract. Now, other disputes were resolved. This question of interpretation was referred to a retired judge. So therefore, what you see is that a matter which would have gone to court or arbitration would have taken years to decide gets resolved. Some of those issues get resolved very quickly, and only one of those issues ultimately goes back to arbitration or litigation. So that's why when I said I referred to ADR as complementary and not as an alternative dispute resolution mechanism. Now you have Consumer Protection Act 2019. You have the Real Estate Regulation and Development Act 2016, RERA for short. Now, under the Consumer Protection Act 2019 amendment, now you have Chapter 5 from Section 74 to 81, which talk of setting up of conciliation centers or mediation centers, which are annexed to the district forums, the state forums, and the national forum. Under the RERA, you have 32G, which puts an obligation on the authority that conciliation or other forms of facilitation of conflict dispute should be explored. Now, with this, the real estate and infrastructure projects, they have now provided for institutional mediation through establishment of these mediation and conciliation centers. Remember, most construction contracts suffer from delays in completion. These contracts are obtained through a competitive hard bid process. Project failures of large size, which are driven through continuous change orders, because during the process of execution of contract, there are new change orders which keep coming depending on the situation which arises. They lead to disputes. Now, failures would also bring about reputational risk and may, due to their magnitude, even cause bankruptcy for contractors and their supply chain from whom they have got material. Now, in order to deal with such situations, now there is a collaborative model like collaborative contracting has started. It has developed to optimize owner-contractor collaboration, which focuses on dispute prevention and early resolution. See, almost all contracts are owner-driven. They are made by the owner. And the contractor signs on the dotted lines, the person who bids and gets that contract. But under this collaborative contracting method, both the contractor and owner sit together and put in their heads before even starting the work, thus reducing chances for disputes which may arise because they both put in their own expertise while setting up clauses and agreements, because mostly they have no fault clauses. So far as mediation is concerned, it's already been talked about. It's a voluntary process in which the mediator assists the parties in reaching an agreement in a collaborative, consensual, and informed manner. The parties jointly select a mediator whose role is to assist in reaching a mutually satisfactory resolution of the dispute. Now, most construction-related disputes at the bottom are about money. Mediation offers creative solutions through negotiation. It is a unique opportunity to speak directly to an adversary and its decision makers. See, when dispute starts between the contractor and the owner, they don't even interact. They don't even talk to each other. When mediation is resorted to, parties, both the decision makers, sit across the table and try and find a solution. Now, this is a unique opportunity. Values are traded off. Something which is more important to someone, for example, money may be more important to someone. For the contractor, the time may be more important. See, for the owner, shorter the time, it's better. So the owner can agree on more money to be paid or maybe additional work to be paid. And these values are traded off that may cost little to the offerer, but help in sweetening the deal. For example, let me give you an example. A contractor claiming losses on a project might accept structured payments over time. You see, because let's say the owner is not in a position to make time. So you can have installments within which the payments to be made. Or the owner can offer additional work in lieu of the full amount of money that could be claimed. An owner could accept correction of defective work or an extended warranty in lieu of direct monetary compensation. Now, all these things can only happen when parties sit across the table and negotiate, which doesn't happen in court, which doesn't happen in arbitration. Arbitrator will decide who's wrong, who's right, whether the time extension should be given, time extension should not be given, whether liquidated damages should be imposed and should not be imposed. But these kind of solutions can only happen through mediation and negotiation. See, both sides might benefit from the agreement on a public statement regarding successful completion of the project. See, the contractor needs a certificate that this particular contract of such and such magnitude coming from a public sector enterprise was completed successfully. So it is actually a building up of reputation. So that may be more important for the contractor than actually asking for some more money. Further, if the entirety of dispute cannot be resolved, the parties may agree to resolve a portion of the conflict, as I said, and direct the remainder of the dispute to resolution by some efficient mechanism, such as engagement of a neutral third-party engineer. As I said, project neutral. You can have somebody else who can look into those particular disputes where parties don't agree before actually even resorting to arbitration or litigation. All this is important with the right mediator and cooperation between the parties. Creative solutions may emerge which were not even in the contemplation of the parties. This is the beauty of mediation. Mediation Act 2023 recognizes the efficacy of online mediation. Section 30 emphasizes the integrity of the process to include confidentiality. So now ODR is becoming very important. India's digital economy is undergoing transformation, which has redefined consumer market interactions, necessitating an evolution in dispute resolution mechanisms. There is thus a need for an efficient online dispute resolution ODR system. The current legal framework is inadequate to handle the volume and nature of disputes generated by this digital shift. You know, I'm told more than 5 lakh cases are pending in NCDRC or in the consumer courts. ODR system is quicker, more efficient, and an accessible solution for resolving disputes. Now, COVID-19 actually threw up a big challenge for us. Those were difficult times. At the Delhi High Court Mediation and Conciliation Center, Samadhan, we adapted ourselves to the situation with utmost expedition. Let me tell you, during the COVID period, mediations were conducted online with the parties and the mediator being within the comfort of their homes. The result of such efforts were very encouraging. Today, online mediation has become an asset and a very promising alternative whenever the parties are placed at different places across the globe. We have done matters where one of the parties was in Dubai, other was in America. We have done cases where parties were not able to come from Bombay to Delhi physically, and we did a hybrid system where parties who were in Delhi were present at the center, while the party who was in Bombay joined online. So this is a method which now is here to stay. But let me tell you, there are several challenges for adoption of ODR in India, which include lack of awareness and availability of infrastructure. There are issues relating to security of data to maintain confidentiality. Even under the Consumer Protection Act now, the Consumer Protection Act E-Commerce Rules 2020 have been promulgated, which mandate internal grievance mechanisms. Online case filing systems are being put in place, which saves physical travel. You don't have to travel to the place to file your complaints. You can sit at home and upload complaints. Looking at the effectiveness of mediation conciliation for construction disputes, let me tell you, several public sector enterprises have created internal mechanisms to implement mediation. Let me name a few to you. Indian Oil Corporation Limited has formulated IOCL Conciliation Rules 2014. National Highway Authority of India has framed National Highway Authority Policy Guidelines Conciliation and Settlement of Contractual Disputes 2017. Gas Authority of India Limited, GAIL India Limited Conciliation Rules 2010. Power Grid Corporation of India Limited, Clause 45 of Section 7 of General Conditions of Contract and Section 8 of Specific Conditions of Contract. Almost all the contracts have those GCC and SPC and SEC. So even now, these public sector undertakings, which are almost, they say 60%, more than 60% litigation today in court is involving the government or these enterprises which are owned by the government. Now, Section 19 of the Mediation Act provides that, see, now question of enforcement. Section 19 of the Mediation Act provides that once a mediator settlement agreement is signed by the parties and authenticated by the mediator, that is mediator who's now on the rolls of MCI, the Mediation Council of India, which is going to be formed. And it is final and binding like a decree, which is enforceable under the Civil Procedure Code. So you don't have to go back to the court, like under the arbitration, if it is challenged. The challenge also is provided under the Mediation Act, but it's very limited. But various provisions of the Mediation Act are yet to be brought into force. Disputes on construction projects cannot be avoided, but arbitration and legal proceedings can be. With a little diligence, creativity, and sound judgment, negotiation by far the best way to resolve a dispute. It is cost-effective, speedy, and importantly, it gives parties control over the outcome. Added to that, online dispute has the potential, or that dispute resolution has the potential to reduce the time taken to dispute resolution, the statistics say, by nearly 70%. So this is the future of mediation. I hope, you are actually enthused by the fact that mediation is here to stay. It's being adopted. And we need to actually spread awareness so that parties realize that this is a process which is actually available to them and can be resorted to for almost all disputes, including contractual disputes in terms of high value projects, whether it's the infrastructure or the builder owner disputes, developer disputes. So mediation is here to stay. And I'm sure, like now the question was about training. Yes, there are several institutes which are offering training. This 40-hour training is available, and parties can resort to that. As I said, it's not just meant, actually dissolution of disputes in courts, resolution of disputes. It's about, and actually we need these skills in negotiation and communication. It's very rarely said that communication is not about only talking, it's about listening, which is actually, something which we need to learn. Thank you so much. Thank you for patiently hearing.
Thank you, sir. I have one question for you.
Yes.
In mediation, I personally found there is a large bargaining between the parties. The bargaining size is very high. So how we can come close to the bargaining ratio so that our mediation is successful?
There is let me tell you, there's a little difference between bargaining and negotiation. Bargaining is mostly concerning economic advantage. So everybody wants to get a better economic advantage. Negotiation is about trading of values. The gap that you just now talked about, we have a term when you do the training, a term which is used, which is called ZOPA, Zone of Possible Agreement. And while dealing with the zone of possible agreement, we have certain concepts like Patna Vatna. We do a little bit of reality testing. See, it's very easy to say when the parties stick to positions, when they take their positions about one says 50 crores, the other says 500 crores. Now, how do you bridge this gap? This gap is bridged by doing reality testing. If you were to go to court, would you be in a position to realize this 500 crores? Then when will you realize it? When will you get this money? By that time, the man would be bankrupt. See, today, the man needs the money today to run the contract, to actually execute the contract. But if he has no finances, he is not able to pay his suppliers. Suppliers will be bankrupt. They would drag him to court. He takes the person to the court. Arbitration, you know how many years it takes, how expensive it is. And then ultimately, when you get the award, when do you realize the fruits? By that time, maybe even the owner has become bankrupt. So where do you get your money? So what we do to bridge that gap is to do reality testing. And that's one of the very, very important tools which is used by the mediator to bring the parties to the table to see, reason, and decide for themselves what is being offered, whether it is good to be taken today, or whether we should wait 20 years down the line and maybe not realize the money. And that's why these settlements are happening and these, gaps are being bridged. And it's, I'll give you a very good, very simple example when you said that. In a MSCT matter, I mean, almost lawyers or people who are here would, who have practiced on the MSCT side would know that under the Act, there is a formula provided. If the man dies, let's say he was 30 years old, he had this much salary, he had this much dependency, he had this much future prospects, life expectancy so much, you can calculate as to how much money that man would be entitled to in case if he had lived and not died because of the accident. Now, the widow, when resolving dispute with the insurance company, let's say this amount is 20 lakhs, agrees to accept 10 lakhs today. Why? So the question to ask, you ask this lady as to why is it that, you will get 20 lakhs after you litigate, you will be successful. But why are you accepting 10 lakhs? This lady turned around and said, look, the man died, I have 2 young children. If I get these 10 lakhs today, I can actually send my children to school, educate them, and they'll be tomorrow bread earners for me. They will be an asset for me. If I get 20 lakhs, after 10 years, they would have grown like urchins. They will become vagabonds. And their future will be gone. What will I do with that money then? So this reality testing, when it is drawn upon a contractor or on a owner, as to what happens in case if the dispute is settled today versus what you'll get in litigation, most matters get resolved across the table.
Thank you, sir. Thank you for giving insight. And thank you for behalf of GIPA for giving a wonderful elaboration. And you also highlighted the problem we are facing in RERA also. In RERA, there is a lot of conflict is going on and we are facing day on and day out. Apart from our taxation and consultancy, we are only resolving the vendors on behalf of our clients, RERA clients.
Vishalji, an example which is to be adopted is Maharera.
Yeah.
In Maharashtra, they have conciliation benches. And those conciliation benches have one representative of the developer, one representative of the flat buyer, the consumer. And let me tell you, they are settling. I mean, I was told in last 3-4 years, they settle almost 50% of those matters.
Sir, our bill,
so you
sir,
and people like Hiranandani in Bombay who don't need to actually sit in conciliation. They sit as part of the conciliation bench. So in case if you have a builder with that reputation sitting on a conciliation bench, a normal developer will not deviate from what is right and what is wrong. So those disputes are getting resolved. So what we need to do is also look at having such kind of conciliation benches, because RERA, you see, the authority is given a mandate under 32G to set up such conciliation boards or benches. And if that is resorted to, maybe a lot of litigation will come to an end.
Say in Varanasi, I am practicing RERA. So the builder will call us when they dispute arises. They call me and call the vendor too, because he knows the CA will best give mediation to the parties. Both parties will win in situation. Thank you, sir. Thank you for giving a valuable time.
Thank you.
Thank you, sir. Now I like to welcome Dr. Tripti Rathi, ma'am, on behalf of GIPA. Welcome, ma'am. And Tripti Rathi, ma'am, is assistant professor in symbiosis law and in law college, and madam has done his PhD and LM degree from the symbiosis. Madam has a vast experience in the legal field, and he is a visiting faculty. Madam has done a lot of research paper and publication. Madam is a panel member in the Lok Adalat of District Court Pune. And madam, please give an insight about the mediation and how we can move forward to give more benefit to our clients in mediation field.
Good evening, sir. Good evening, all the members, esteemed members. Thank you, Vishal, sir, for introducing me. Thank you. I especially thank CA Parveen Jain, sir, for inviting me here. to talk about the mediation in capital markets or in SEBI. So, yes, immediately I will start my session. I would like to request Vishal sir if I can share my slides here. Thank you, sir.
Wait a minute. I'm just... Praveen sir, please make the course, madam, to course.
Please mute yourself.
Praveen
I
sir,
think now you
please
can
make...
try, Dr. Tripti. Now you can try. It's working.
Sir, I'm unable to share my screen, sir.
Praveen sir, please allow, give him a co-host. I am a co-host. Praveen sir, please allow to make the madam co-host.
Yes, screen.
Yes, sir, can you see my screen, sir?
Yes, yes, ma'am, very much clear.
Okay, and am I audible as well?
Yes, ma'am, yes.
Yeah, thank you, sir. Thank you. So, good evening, all, once again. And yes, I do agree with all my experienced practitioners, seniors, I can say here. Definitely, this arbitration, mediation, arbitration, conciliation, and mediation, these are the very important processes in every field. So here we have covered, or we have talked about global economy. We have talked about the RERA, real estate business. There also we have actually initiated this particular process. Then in insolvency and bankruptcy, process, there also we have introduced the mediation as well, right? And when we talk about this particular process, this is definitely, it is an alternative, or as sir has mentioned, it is a complementary process, wherein the stakeholders will not file the cases with the court of law, and they will find out the solution, just having meetings and talking with each other and convincing each other, or negotiation, I would say here. So, very important pointers here I would like to mention. One thing is that even when we talk about the mediation or this alternative dispute resolution processes, in which in this particular sector, even in medical field also, especially about the drug, and when there is a dispute about the patent, so there also now the matters are referred to the mediators. So even in when I will talk about this, or when I mention about SEBI or capital market. So there also now we talk about, or we have actually introduced the process, that is arbitration, conciliation, and mediation in this particular capital market in our country. So here I am just putting, yes, एक second. Yeah. So here I today in this session, yes, I know I have very less time. So I will try to cover this within 20 minutes, 20 to 25 minutes, because it is, I'm going to talk about this online resolution of disputes in the Indian securities market. That this is a circular, master circular, issued by the Securities Exchange Board of India in the year of 2023. So it is also called as ODR. Sir has already talked about this, or already mentioned about this ODR process. So this particular Securities and Exchange, the Securities Exchange Board of India, very recently have introduced this ODR system or a mechanism, Now, through this particular mechanism, or this particular mechanism is in the interest of investors, or here I would use the term that is the stakeholders. Now, this ODR process is to settle disputes, as I have already mentioned, outside the court. So it is less complex, cost efficient, and speedy, and definitely less technical and informal process. So here ODR is a process to settle disputes outside courts, combining technology. Why technology? Because it is online dispute resolution. So if you will refer to the matters or these cases, even if we'll go through this National Stock Exchange website, there we can see this arbitral award. So there they have mentioned that what kind of technology that they have used, or what such as Microsoft Teams or Zoom, right? This kind of medium that they have mentioned in the draft itself or in the award itself. So the technology is also important. So combining technology and alternative dispute resolution mechanism of conciliation, mediation, and arbitration. So ODR and EDR offers, as I have said already, faster, transparent, cost effective, and it is accessible. Every stakeholder can access this arbitral award or the status of this particular case. Definitely, I will share with you all the relevant websites also where we can see all this. Now, the existing market infrastructure institutions, collectively it is called as market infrastructure institutions. It includes the stock exchanges and depository participants. So, market infrastructure institutions did provide for conciliation and arbitral process, including appellate arbitration. Here in this particular circular also they have mentioned, there is a provision which talks about the appeal. So for resolution of disputes, the same was definitely earlier, before this COVID-19, the process was more offline or physical, you can say. So that was more complex. Non-uniformity was there, and it was restricted only against selected regulatory entities such as stockbrokers, depository participants, listed companies, and registrars and transfer agents. So now, moreover, now the existing process provided for a multi-layered approach. Definitely, I will interpret this. I will explain what is this, a multi-layered approach, requiring the claimant to comply with the certain pre-arbitral actions. Now, here, first thing is that we have this particular mechanism, which is also called as score. So, before this ODR, we had the score. So the SEBI had introduced score. This filing a complaint with the first step is that the person has to file the complaint with the concerned market participant. Then through SEBI complaints redressal system portal. So through this particular system, the complaint has to be filed. Then next is, it is time-bound conciliation process through Investor Grievance Redressal Committee, which is also called as IGRC of the concerned stock exchange. So three important keywords are there. One is you're filing the complaint with the concerned market participant. Second, through SEBI complaints redressal systems. Four, we have the website also. Then this is a time-bound conciliation process through this IGRC. Now, what are the objectives of this particular ODR system or ODR mechanism? It is in the interest of, it is introduced in the interest of the investors. So, here, the existing dispute resolution mechanism in the Indian securities market is being streamlined under the aegis of stock exchanges and depositories. As I have already mentioned, it is collectively called as a MII. Secondly, by expanding their scope and by establishing a common online, now it is a common online dispute resolution portal, is called as ODR portal. Now, which harness online conciliation and online arbitration for resolution of disputes arising in Indian securities market. So here brokers are involved, agents are involved. I am going to discuss with you all some few cases filed or the arbitration proceedings where is held, and then we can talk about the arbitrational award as well. Next is ODR is applicable to this disputes between investors, clients, then listed companies. including their registrar and share transfer agents or any other specified intermediaries and regulated entities in securities market will be resolved by harnessing online conciliation or online arbitration. It is also applicable to the listed companies, specified intermediaries, regulated entities, and their clients or their clients or investors. It also includes the account of nominations or transmission being given effect to. Now, this is also applicable to disputes between institutional or corporate clients. Now, this especially the specified intermediaries and regulated entities in the securities market. The details are mentioned in Schedule B of this master circular. Now, next is by harnessing. Now, here for this online arbitration, online conciliation, or for this alternative dispute resolution mechanism, they have specifically mentioned that they need independent institutional mediation, independent institutional conciliation, independent arbitration institution. Now, independent is already defined in the various committees established in our country. So I'm talking or I'm referring to the committees established to develop the concept of corporate governance. So there they have defined the term independent. Independent, not biased, not related to the parties. There they have referred not related to the company or with the affairs of the company. So in that particular sense, this independent is very important. The seat and venue of mediation, conciliation, or arbitration shall be in India and can be conducted online. Though this one statement is not only mentioned in the circular, the details are there, like where exactly this online proceedings can be held. So all the details are mentioned in the master circular. Next, about the fees, charges, cost. As per the amount, it is clearly mentioned that what would be the fees for the conciliation, what would be the fees for the arbitration. So it is clearly mentioned, and who is going to pay that particular fees. It is also mentioned in master circular. Next is the claims, complaints, disputes that arise from the activities or roles performed or to be performed by the specified intermediaries or regulated entities pertaining to the Indian securities market are now in scope of this clause. So here they have clearly mentioned that this particular clause is applicable to the claims, complaints, disputes which are related to the Indian securities market. Next is very important that there they have used the term impanel the ODR institution. So every MII has to ensure this impanel the ODR institutions to execute this particular mechanism. So this ODR portal, and as earlier I have mentioned the score. So this score portal and ODR portal is connected. Here under SEBI has delegated the responsibility of grievance redressal in relation to all securities market intermediaries to MII and ODR institutions. So two things are very clear. So we have mechanism. The mechanism is introduced by SEBI. Secondly, we have MII. So their role is also mentioned in the circular. And then we have ODR institutions. They are going to, they execute this particular mechanism. Now, however, under the scores portal, SEBI maintains oversight and disposes of investor complaints file. While the listed entity, SEBI registered intermediary, continue to be directly responsible for redressal of investor complaints. So they have segregated the role. SEBI maintains oversight or disposes of investor complaints file. The listed entity, SEBI registered intermediary, they continue to they continue to be directly responsible for redressal of investor complaints. Now, ODR portal offers a platform to the investors to file the complaint in case of the investor is not satisfied with the resolution of the complaints raised directly with the concerned market participant. So ODR is there when the investor is not satisfied with the resolution. which is provided by that concerned market participant, which is also, for an example, any of the listed company or specific intermediaries or regulated entities in the securities market. Now, either prior to escalation through scores portal or post escalation through scores portal. So two options are there. Even either prior to this escalation or after the escalation also, you can actually avail this particular or you can approach to this particular system or a mechanism. So and also apart from investors, it is this platform is available to the market participant to initiate the dispute resolution through ODR portal after providing the investor. Now there is a condition that for the market participant, if they want to initiate this particular proceeding, that has to be done after the 15 days calendar days notice for resolution of pending dispute. Now, furthermore, dispute resolution through the ODR portal can be raised only when it is within the applicable. Now, law of limitation or limitation act is applicable here. And when it is not under consideration under SCORES guidelines. So here they have excluded like what is not possible under or what is not included or what is not applicable, that is ODR. So here, first thing is a limitation act is applicable. Second, if it is not under the consideration under SCORES guideline, if it is not pending before any court, consumer forum, arbitral process, or it is not arbitral according to Indian law. And one more important pointer that they have mentioned in the master circular, that if the case is pending or this is the company is facing insolvency proceedings, and there they have received this particular order, that is a moratorium. So moratorium period is going on in that particular case is also the ODR is not applicable. And if your case is against the government of India, president of India, or the state government, governor of a state, then it is not included. Next is conciliation. So the first step, it is clearly mentioned. I will show you the chart also, that it becomes easy to understand what it exactly what it is, the ODR. So the first is the conciliation. After score, the next is conciliation. So upon registration of complaint on the ODR portal, first is it proceeds to online conciliation. So online conciliation will be there. Now, by whom? By sole, independent, and neutral conciliator. Now, here, if you will ask me what is the qualification of this conciliator or arbitrator, it is also mentioned in the schedule of master circular, that is the qualification, required qualification, expertise of this mediator and conciliator and arbitrator. So after fulfilling those conditions only, the person can be appointed here as a conciliator. So sole, independent, and neutral conciliator appointed from the panel of conciliators by the ODR institutions. Now schedule D to the ODR circular. Here I have already mentioned that the details are mentioned in schedule D about this qualitative norms for impanelment of the concerned conciliator. The conciliator's appointment is to be done within 5 days. Today you have received the dispute. Within 5 days, the conciliator should be appointed. Next is the ODR portal prescribes. Now here, I would say that the one of the important feature of this ODR is the strict, they have given us a timelines. So a strict time frame for resolution of disputes, that is 21 days. So it can be extended, but not more than 10 days through online conciliation by a sole conciliator. So that is a discretion of conciliator. So if conciliation is successful, then a settlement agreement is to be executed and stamped through an online mode, and the MIIs are tasked with monitoring the due payment or adherence to the settlement agreement. So first is conciliation. Conciliation, there are conditions who can be is eligible to do this conciliation. Second, timelines need to be followed. Third, that the role and the responsibilities of MII. So it is clearly mentioned that monitoring the due payment and adherence to the settlement agreement will be ensured by MII. Next is, if the conciliation is not successful, then arbitration is the next step. So if the grievance is not successfully resolved through online conciliation, then the conciliator will ascertain the value of, now here the conciliator will ascertain the value of admissible claim. This value is really important, and notify the disputing parties, ODR institutions and the MII of the same, and thereafter online arbitration is initiated as per the ODR 18 ODR circular. So here one thing, if conciliation is not successful, then the parties can go to the arbitration. Second is, prior to initiation of this online arbitration, this is again one of the important condition. The market participant must deposit 100% of the admissible claim value. Here I would like to mention that this is a very important condition. I would say it is very stringent, strict condition than the civil court. To resolve this kind of matters, especially when we talk about the securities market or capital market, this kind of conditions are very crucial. So here the condition is that even to initiate this particular proceeding, the market participant must deposit 100% of admissible claim value with the relevant MII and make payment of fees. Now, next is here also we need a sole, independent, and neutral arbitrator has to be appointed from its panel of arbitrators within 5 calendar days of reference by the institutions. Now, the arbitral hearing will be conducted subject to the value of claim or counterclaim. Claim and counterclaim is having the meaning. For instance, if the value of claim or counterclaim, now here there is a condition as it depends on the value. So the claim or counterclaim is in excess of rupees 1 lakh, then sole arbitral or arbitral tribunal shall conduct one or more hearings and pass the arbitral award within 30 days. Now, next is, similar time frame is in place for claims or counter claim of rupees 1 lakh or below. But in below 1 lakh, they said that the sole arbitrator shall conduct a document only arbitration process and pass the arbitral award within 30 days, calendar days. Now, however, the arbitrator can grant hearing to the parties for recorded reasons. Now, here one thing that the value, it depends on the value, that what kind of proceedings would be there. Same proceedings, but the method would be different slightly, I would say. In furtherance of the conclusion of arbitration proceedings, the issuance of arbitral awards, if the terms of such award required payment of any amount, then same shall be done within 15 days. So for everything, for filing, Limitation Act is there. Second, for completing this particular proceeding, there is a timeline. To appoint the conciliator or arbitrator, there is a timeline. So everywhere they have ensured this timelines. Next is, moreover, if the market participant wishes to challenge such an arbitral award, now for challenge or again, this is important. Then the intention to challenge the same under Section 34 Arbitration Act 1996 should be done within 7 days, calendar days in the ODR portal. Now, everything, even if you want to challenge, you have to do this through this particular portal, that is ODR portal. Next is, if stay is not granted within 3 months from the date of receipt of award, then award has to be executed. That means the complete adherence to the terms of award becomes mandatory. Another distinct feature of arbitration under ODR portal is in the process of implementation award, now which is unique. The market participant wishing to challenge the arbitral award. Now here, for filing arbitral award, for challenging this particular arbitral award, now here also deposit is required. That is the kind of security, 100% of the amounts payable in terms of arbitral award with the relevant MII prior to the initiation of this particular challenge. So including prior to the initiation of online arbitration, which I have already mentioned. Failing which, now here if you have not paid this particular deposit, now these are the repercussions, I would say. One is liable to be declared as not fit and proper. Fit and proper is defined, the criteria are also mentioned in SEBI Intermediaries Regulations 2008. Fit and proper is also mentioned in Insolvency and Bankruptcy Code. Next is, if you fail to pay this particular deposit, then you will be declared as not fit and proper. Second, that particular concerned person will be liable to have its registration cancelled. So registration will be cancelled, and even next is the business activities will be suspended. So very stringent conditions are mentioned to ensure that the mediation or conciliation or arbitration will be successful. Now, a listed company that fails to deposit the amount may also face consequences as determined necessary or appropriate by stock exchange, which I have already mentioned. Now, fixing the deposit amount at 100% ensures the market participant, it is creating the deterrent effect from prolonging a dispute. And ODR is established as an effective remedy in comparison to other civil remedies. That is the reason I have said that they have put better conditions than civil courts. Because we observed in Mahalok Adalat, Lok Adalat, that how things are getting complicated in the civil courts, especially. And in Mahalok Adalat, we find out the solution. Even I would like to give one example. People use this credit cards especially, and they have due payments, huge payments. I would say huge payments. So there also they try to resolve this kind of, even the banker will be there, the concerned person, the defaulter will be there, and the third party will be there as a part of Mahalok Adalat, and then they try to resolve this particular, because such a kind of issues and so many issues or so many cases, the judiciary is not having that kind of efficient mechanism to resolve this kind of issues, I would say, speedily. So that is the reason this particular mechanism is better than this traditional way of resolving issues. So further, MIIs are obligated to make payouts not exceeding rupees 5 lakhs. That is also a condition from such deposited amount upon application being made by the investor or client. So if the investor or the client has made the application, the MII is obligated to make the payout but not exceeding 5 lakhs. Next is MII is also obligated to obtain appropriate undertaking, indemnity, security from the investor client to ensure return of the amount so released in case the challenge is decided against the investor or client. Now here, if it is decided against investor or client, then in that particular scenario, it is also a very important thing to note that they have to, this investor client has to return the particular amount. If the investor client fails to return the amount, there are also the repercussions. Here it is clearly mentioned that then the investor client based on PAN of investor client shall not be allowed to trade. So a trade on any of the stock exchanges or participate in Indian securities market till such time the investor client returns the amount to the market participant. Secondly, the securities which are there in demat account or mutual fund holdings of investors clients shall be frozen till such time as the investor client returns the amount to the market participant. So in the event of challenge is decided in favor of investor client, then subject to the terms of judgment of the appellate forum, the MII shall release the balance deposit held by it to the investor or client. So for both the parties, I would say that is a, this is completely based on principles of equality, principles of natural justice. So for both the parties, they have ensured that they are going to take the securities, and if they are not going to pay, then what would be the actions taken by this particular concerned authority. So the MII shall also monitor the due compliance by the market participant with the terms of arbitral award, judgment of the appellate forum. Now, form of proceeding, venue and place, fees and charges, detail, everything in detail is mentioned in the master circular of ODR. Secondly, empanelment and training of the panel of conciliator and arbitrator is also mentioned in the master circular. Now, this is just whatever is mentioned in my 19 slides. This is mentioned in one slide. So this is very easy to understand exactly how it is executed, this ODR mechanism. So one more thing I would like to mention. Oh, I know time up, but I would like to show. Yeah. Now this is the website of NSE. There you can find the list of this, the arbitrators, conciliators. That is one thing. Second thing, here these are the cases. Now this, all the details I have taken from the website, so it is accessible. The stakeholders can access this particular. So what kind of award, what kind of dispute was there. So especially in this, if you will see, just I know I have to stop. Just give me 5 minutes. Okay, so I just want to mention one thing, that it is successful. This particular mechanism is successful because, see here, Microsoft Teams meeting, this particular forum that they have mentioned, but no, not, I don't want to talk about the rejection. I will talk about the success. So yes, so this is a successful arbitration award. So here they have clearly mentioned the award is given by the arbitrator. The respondent is hereby directed to pay an amount of rupees 60,000, 60,003 only, to the applicant within 15 days from the date of this award, failing which an interest shall be accrued, that is at the rate of 8% per annum from the date of expiry of the said 15 days. So that means here the parties got the I can say the resolution. So not the entire amount, but the 50% amount the party has received. So this is how this particular mechanism, I would say that it is becoming successful, as sir has also clearly mentioned that in Australia, in this kind of countries, they this kind of mechanism is successful. In India, we are taking time, but I would say that we have a good percentage of this particular cases wherein we got the success through this arbitration conciliation. And with this, I would like to stop myself. Thank you.
Thank you, ma'am. You have given a detailed deliberation, and you have taken all the points in step by step, so we clearly understand. And now I hand over to the session to Praveen sir. Please give the vote of thanks to all the dignitaries.
Good evening to everyone. I, on behalf of GIPA, ADRP, APAR Professional, and PJ Group of Companies, to give a vote of thanks to our guest of honor, Dr. Anuj Goyal, Dr. S.K. Gupta, our eminent speakers, Mr. J.P. Singh, Senior Advocate, Mediator and Trainer, IP, and Sanjeev Ahuja, Mediator and Trainer, President, Missing Bridge, and Dr. Trupti Rathi, Assistant Professor, Symbiosis Law School, Pune, and our organizing committee, Vice Advocate Pusyan, CA Pushpender Dikshit ji, and CA Vishal Singh ji, our joining organizing committee. Thanks a lot to all, and wishing you a happy today and tomorrow happy Sunday, happy family Sunday.
Thank you.
Thank you,
sir, just a second. I'm so sorry. Don't disconnect, because I got one request. So I'm just putting link here. Just a second. Give me 1 second. 1 second.
We will meet in shortly with,
yes,
with another webinar on the same subject. Right, sir? Thank you, sir. Thanks a lot.
Thank you, sir. Thank you. Thank you.
Also.
Thank you, madam.
Thank you. Thanks for a much better presentation for SEBI and capital market.
What, sir?
I want to know that your presentation for SEBI and capital market is also very much appreciated.
Oh, thank you, sir. Thank you, sir. Thank you.